Section 25, Ignorance of law. The fact that an offender is ignorant of the law is not an excuse for any offense committed by him or her. Breach of the peace. Section 42, Preventing breach of the peace. 1. Everyone who witnesses a breach of the peace is justified in interfering to prevent its continuance or renewal, and may detain any person committing it, in order to give him or her into the custody of a constable, provided that the person interfering shall use no more force than is reasonably necessary for preventing the continuance or renewal of the breach of the peace, or than is reasonably proportionate to the danger to be apprehended from its continuance or renewal. 2. Every constable who witnesses a breach of the peace, and every person lawfully assisting him or her, is justified in arresting anyone whom he or she finds committing it. 3. Every constable is justified in receiving into custody any person given into his or her charge, as having been a party to a breach of the peace, by one who has witnessed it or whom the constable believes on reasonable and probable grounds to have witnessed it. Defense against assault. Section 48, Self-defense and defense of another. Everyone is justified in using, in the defense of himself or herself or another, such force as, in the circumstances as he or she believes them to be, it is reasonable to use. Crimes Act 1961. Section 9, Offences not to be punishable except under New Zealand Acts. No one shall be convicted of any offence at common law, or of any offence against any Act of the Parliament of England or the Parliament of Great Britain or the Parliament of the United Kingdom, provided that a. Nothing in this section shall limit or affect the power or authority of the House of Representatives or of any court to punish for contempt. b. Nothing in this section shall limit or affect the jurisdiction or powers of the court-martial, or of any officer in any of the New Zealand forces. Section 10, Offence under more than one enactment. 1. Where an act or omission constitutes an offence under this act and under any other act, the offender may be prosecuted and punished either under this act or under that other act. 2. Where an act or omission constitutes an offence under two or more acts other than this act, the offender may be prosecuted and punished under any one of those acts. 3. Where an act or omission constitutes an offence under two or more provisions of this act or of any other act, the offender may be prosecuted and punished under any one of those provisions. 4. No one is liable to be punished twice in respect of the same offence. Section 10A, Criminal enactments not to have retrospective effect. Notwithstanding any other enactment or rule of law to the contrary, no person shall be liable in any criminal proceedings in respect of an act or omission by him or her if, at the time of the act or omission, the act or omission by him or her did not constitute an offence. Part 3. Matters of justification or excuse. Section 20, General rule as to justifications. 1. All rules and principles of the common law which render any circumstances a justification or excuse for any act or omission, or a defense to any charge, shall remain in force and apply in respect of a charge of any offense, whether under this act or under any other enactment, except so far as they are altered by or are inconsistent with this act or any other enactment. 2. The matters provided for in this part are hereby declared to be justifications or excuses in the case of all charges to which they are applicable. Section 21, Children under 10. 1. No person shall be convicted of an offence by reason of any act done or omitted by him or her when under the age of 10 years. 2. The fact that by virtue of this section any person has not been or is not liable to be convicted of an offence shall not affect the question whether any other person who is alleged to be a party to that offence is guilty of that offence. Section 22, Children between 10 and 14. 1. No person shall be convicted of an offence by reason of any act done or omitted by him or her when of the age of 10 but under the age of 14 years, unless he or she knew either that the act or omission was wrong or that it was contrary to law. 2. The fact that by virtue of this section any person has not been or is not liable to be convicted of an offense shall not affect the question whether any other person who is alleged to be a party to that offense is guilty of that offense. Section 25. Ignorance of law. The fact that an offender is ignorant of the law is not an excuse for any offense committed by him or her. Use of force. Section 39. Force used in executing process or in arrest. Where any person is justified, or protected from criminal responsibility, in executing or assisting to execute any sentence, warrant, or process, or in making or assisting to make any arrest, that justification or protection shall extend and apply to the use by him or her of such force as may be necessary to overcome any force used in resisting such execution or arrest, unless the sentence, warrant, or process can be executed or the arrest made by reasonable means in a less violent manner. Provided that, except in the case of a constable or a person called upon by a constable to assist him or her, this section shall not apply where the force used is intended or likely to cause death or grievous bodily harm. Breach of the peace. Section 42. Preventing breach of the peace. 1. Everyone who witnesses a breach of the peace is justified in interfering to prevent its continuance or renewal, and may detain any person committing it, in order to give him or her into the custody of a constable, provided that the person interfering shall use no more force than is reasonably necessary for preventing the continuance or renewal of the breach of the peace, or than is reasonably proportionate to the danger to be apprehended from its continuance or renewal. 2. Every constable who witnesses a breach of the peace, and every person lawfully assisting him or her, is justified in arresting anyone whom he or she finds committing it. 3. Every constable is justified in receiving into custody any person given into his or her charge, as having been a party to a breach of the peace, by one who has witnessed it or whom the constable believes on reasonable and probable grounds to have witnessed it. Defense against assault. Section 48. Self-defense and defense of another. Everyone is justified in using, in the defense of himself or herself or another, such force as, in the circumstances as he or she believes them to be, it is reasonable to use. Defense of property. Section 52. Defense of movable property against trespasser. 1. Everyone in peaceable possession of any movable thing, and everyone lawfully assisting him or her, is justified in using reasonable force to resist the taking of the thing by any trespasser or to retake it from any trespasser, if in either case he or she does not strike or do bodily harm to the trespasser. Section 53. Defense of movable property with claim of right. 1. Everyone in peaceable possession of any movable thing under a claim of right, and everyone acting under his or her authority, is protected from criminal responsibility for defending his or her possession by the use of reasonable force, even against a person entitled by law to possession, if he or she does not strike or do bodily harm to the other person. Section 54. Defense of movable property without claim of right. 1. Everyone in peaceable possession of any movable thing, but neither claiming right thereto nor acting under the authority of a person claiming right thereto, is neither justified in nor protected from criminal responsibility for defending his or her possession against a person entitled by law to possession. Section 55. Defense of dwelling house. Everyone in peaceable possession of a dwelling house, and everyone lawfully assisting him or her or acting by his or her authority, is justified in using such force as is necessary to prevent the forcible breaking and entering of the dwelling house by any person if he or she believes, on reasonable and probable grounds, that there is no lawful justification for the breaking and entering. Section 56. Defense of land or building. 1. Everyone in peaceable possession of any land or building, and everyone lawfully assisting him or her or acting by his or her authority, is justified in using reasonable force to prevent any person from trespassing on the land or building or to remove him or her therefrom, if he or she does not strike or do bodily harm to that person. Section 57. Assertion of right to land or building. 1. Everyone is justified in peaceably entering in the daytime on any land or building to the possession of which he or she, or some person under whose authority he or she acts, is lawfully entitled, for the purpose of taking possession thereof. Section 58, Exercise of right of way, etc. Everyone lawfully entitled to enter on any land for the exercise of any right of way or other easement or profit is justified in peaceably entering on the land for the purpose of exercising that right of way, easement, or profit. Provided that if anyone so entering has noticed that his or her right to use that way or easement, or to take that profit, is disputed by the person in possession of the land, an assault committed by that person, or by any person acting under his or her authority, for the purpose of making the person entering desist from entry, shall be deemed to be provoked by the person entering. Powers of discipline. Section 59, Parental control. 1. Every parent of a child and every person in the place of a parent of the child is justified in using force if the force used is reasonable in the circumstances and is for the purpose of a. Preventing or minimizing harm to the child or another person, or b. Preventing the child from engaging or continuing to engage in conduct that amounts to a criminal offense, or c. Preventing the child from engaging or continuing to engage in offensive or disruptive behavior, or d. Performing the normal daily tasks that are incidental to good care and parenting. 2. Nothing in subsection 1, or in any rule of common law justifies the use of force for the purpose of correction. 3. Subsection 2 prevails over subsection 1. 4. To avoid doubt, it is affirmed that the police have the discretion not to prosecute complaints against a parent of a child or person in the place of a parent of a child in relation to an offense involving the use of force against a child, where the offense is considered to be so inconsequential that there is no public interest in proceeding with a prosecution. Section, Excess of force. Everyone authorized by law to use force is criminally responsible for any excess, according to the nature and quality of the act that constitutes the excess. Section 64, Obedience to de facto law. Everyone is protected from criminal responsibility for any act done in obedience to the laws for the time being made and enforced by those in possession de facto of the sovereign power in and over the place where the act is done. Part 4. Parties to the commission of offenses. Section 66, Parties to offenses. 1. Everyone is a party to and guilty of an offense who a. Actually commits the offense, or b. Does or omits an act for the purpose of aiding any person to commit the offense, or c. Abets any person in the commission of the offense, or d. Incites, counsels, or procures any person to commit the offense. 2. Where two or more persons form a common intention to prosecute any unlawful purpose, and to assist each other therein, each of them is a party to every offense committed by any one of them in the prosecution of the common purpose if the commission of that offense was known to be a probable consequence of the prosecution of the common purpose. Section 71, Accessory after the fact. 1. An accessory after the fact to an offense is one who, knowing any person to have been a party to the offense, receives, comforts, or assists that person or tampers with or actively suppresses any evidence against him or her, in order to enable him or her to escape after arrest or to avoid arrest or conviction. 2. No person whose spouse or civil union partner has been a party to an offense becomes an accessory after the fact to that offense by doing any act to which this section applies in order to enable the spouse or civil union partner, or the spouse, civil union partner, and any other person who has been a party to the offense, to escape after arrest or to avoid arrest or conviction. Section 72, Attempts. 1. Everyone who, having an intent to commit an offense, does or omits an act for the purpose of accomplishing his or her object, is guilty of an attempt to commit the offense intended, whether in the circumstances it was possible to commit the offense or not. 2. The question whether an act done or omitted with intent to commit an offense is or is not only preparation for the commission of that offense, and too remote to constitute an attempt to commit it, is a question of law. 3. An act done or omitted with intent to commit an offense may constitute an attempt if it is immediately or proximately connected with the intended offense, whether or not there was any act unequivocally showing the intent to commit that offense. Part 5. Crimes against public order. Treason and other crimes against the sovereign and the state. Section 73, Treason. Everyone owing allegiance to the sovereign in right of New Zealand commits treason who, within or outside New Zealand, a. kills or wounds or does grievous bodily harm to the sovereign, or imprisons or restrains her or him, or b. levies war against New Zealand, or c. assists an enemy at war with New Zealand, or any armed forces against which New Zealand forces are engaged in hostilities, whether or not a state of war exists between New Zealand and any other country, or d. incites or assists any person with force to invade New Zealand, or e. uses force for the purpose of overthrowing the government of New Zealand, or f. conspires with any person to do anything mentioned in this section. Section 74, Punishment for treason or attempted treason. 1. Except as otherwise provided in this Act, everyone who commits treason within the meaning of any of the provisions of paragraphs a. 2, e. of Section 73 shall upon conviction be sentenced to imprisonment for life. 2. Everyone is liable to imprisonment for a term not exceeding 14 years who commits treason within the meaning of paragraph f. of the said Section 73. 3. Everyone is liable to imprisonment for a term not exceeding 14 years who, owing allegiance to the sovereign in right of New Zealand, attempts to commit treason within or outside New Zealand. Section 75, Evidence of Treason. 1. No one shall be convicted of treason on the evidence of one witness only, unless the evidence of that witness is corroborated in some material particular by evidence implicating the defendant. 2. Nothing in subsection 1 shall apply to treason within the meaning of paragraph a. of Section 73. Section 76, Punishment for being party to treason. Everyone is liable to imprisonment for a term not exceeding 7 years who a. becomes an accessory after the fact to treason, or b. knowing that a person is about to commit treason, fails without reasonable excuse to inform a constable as unlawful assemblies, riots, and breaches of the peace. Section 86, Unlawful Assembly. 1. An unlawful assembly is an assembly of 3 or more persons who, with intent to carry out any common purpose, assemble in such a manner, or so conduct themselves when assembled, as to cause persons in the neighborhood of the assembly to fear, on reasonable grounds, that the persons so assembled a. will use violence against persons or property in that neighborhood or elsewhere, or b. will, by that assembly, needlessly and without reasonable cause provoke other persons to use violence against persons or property in that neighborhood. Provided that no one shall be deemed to provoke other persons needlessly and without reasonable cause by doing or saying anything that he or she is lawfully entitled to do or say. 2. Persons lawfully assembled may become an unlawful assembly if, with a common purpose, they conduct themselves in such a manner that their assembling would have been unlawful if they had assembled in that manner for that purpose. 3. An assembly of 3 or more persons for the purpose of protecting the house of any one of their number against persons threatening to break and enter that house in order to commit an offense therein is not unlawful. 4. Every member of an unlawful assembly is liable to imprisonment for a term not exceeding 1 year. Soon as possible or to use other reasonable efforts to prevent its commission. Section 91, Forcible Entry and Detainer. 1. Everyone commits forcible entry when, by force or in a manner that causes or is likely to cause a breach of the peace or reasonable apprehension of a breach of the peace, he or she enters on land that is in the actual and peaceable possession of another for the purpose of taking possession, whether or not he or she is entitled to enter. 2. Everyone commits forcible detainer when, being in actual possession of land without claim of right, he or she detains it, in a manner that causes or is likely to cause a breach of the peace or reasonable apprehension of a breach of the peace, against another who is entitled by law to possession of the land. 3. Whether there was actual possession, or claim of right, is a question of fact. 4. Everyone who commits forcible entry or forcible detainer is liable to imprisonment for a term not exceeding 1 year. Slave dealing. Section 98, Dealing in slaves. 1. Everyone is liable to imprisonment for a term not exceeding 14 years who, within or outside New Zealand, a. sells, purchases, transfers, barters, lets, hires, or in any way whatsoever deals with any person as a slave, or b. employs or uses any person as a slave, or permits any person to be so employed or used, or c. detains, confines, imprisons, carries away, removes, receives, transports, imports, or brings into any place whatsoever any person as a slave or to be dealt with as a slave, or d. induces any person to sell, let, or give himself or herself, or any other person dependent on him or her or in his or her charge, as a slave, or e. in any case not covered by paragraph d. induces any person to sell, let, or give any other person into debt, bondage or serfdom, or f. builds, fits out, sells, purchases, transfers, lets, hires, uses, provides with personnel, navigates, or serves on board any ship or aircraft for any of the purposes in paragraphs a. 2, e, or g. for gain or reward gives in marriage or transfers any woman to another person without her consent, or h. is a party to the inheritance by any person of a woman on the death of her husband, or I. being a parent or guardian of any child under the age of 18 years, delivers that child to another person with intent that the child or his or her labor shall be exploited, or j. agrees or offers to do any of the acts mentioned in this subsection. 2. For the purposes of this section, debt bondage means the status or condition arising from a pledge by a debtor of his or her personal services, or of the personal services of any person under his or her control, as security for a debt, if the value of those services, as reasonably assessed, is not applied towards the liquidation of the debt, or if the length and nature of those services are not limited and defined. Serfdom means the status or condition of a tenant who is by any law, custom, or agreement bound to live and labor on land belonging to another person and to render some determinate service to that other person, whether for reward or not, and who is not free to change that status or condition. Slave includes, without limitation, a person subject to debt bondage or serfdom. Participation in organized criminal group. Section 98A, Participation in organized criminal group. 1. Every person commits an offense and is liable to imprisonment for a term not exceeding 10 years who participates in an organized criminal group. A. Knowing that 3 or more people share any one or more of the objectives, the particular objective or particular objectives, described in paragraphs a. 2, d, of subsection 2, whether or not the person himself or herself shares the particular objective or particular objectives, and b. either knowing that his or her conduct contributes, or being reckless as to whether his or her conduct may contribute, to the occurrence of any criminal activity, and c. either knowing that the criminal activity contributes, or being reckless as to whether the criminal activity may contribute, to achieving the particular objective or particular objectives of the organized criminal group. 2. For the purposes of this Act, a group is an organized criminal group if it is a group of 3 or more people who have as their objective or one of their objectives a. obtaining material benefits from the commission of offenses that are punishable by imprisonment for a term of 4 years or more, or b. obtaining material benefits from conduct outside New Zealand that, if it occurred in New Zealand, would constitute the commission of offenses that are punishable by imprisonment for a term of 4 years or more, or c. the commission of serious violent offenses, or d. conduct outside New Zealand that, if it occurred in New Zealand, would constitute the commission of serious violent offenses. 3. A group of people is capable of being an organized criminal group for the purposes of this act whether or not a. Some of them are subordinates or employees of others, or b. Only some of the people involved in it at a particular time are involved in the planning, arrangement, or execution at that time of any particular action, activity, or transaction, or c. Its membership changes from time to time. Smuggling and trafficking in people. Section 98b, terms used in sections 98c to 98f. In sections 98c to 98f, unless the context otherwise requires. Act of coercion against the person, includes a. Abducting the person. b. Using force in respect of the person. c. Harming the person. d. Threatening the person, expressly or by implication, with the use of force in respect of, or the harming of, the person or some other person. Act of deception, includes fraudulent action arranges for an unauthorized migrant to be brought to a state includes a. Organizes or procures the bringing to a state. b. Recruits for bringing to a state. c. Carries to a state. Arranges for an unauthorized migrant to enter a state, includes a. Organizes or procures the entry into a state. b. Recruits for entry into a state. c. Carries into a state. Document, includes a thing that is or is intended to be a. Attached to a document, or b. Stamped or otherwise signified on a document. Harming of a person, means causing harm of any kind to the person, and, in particular, includes a. Causing physical, psychological, or financial harm to the person. b. Sexually mistreating the person. c. Causing harm to the person's reputation, status, or prospects. Unauthorized migrant, in relation to a state, means a person who is neither a citizen of the state nor in possession of all the documents required by or under the law of the state for the person's lawful entry into the state. Section 98d, Trafficking in persons. 1. Every person is liable to the penalty stated in subsection 2, who arranges, organizes, or procures a. The entry of a person into, or the exit of a person out of, New Zealand or any other state. I. For the purpose of exploiting or facilitating the exploitation of the person, or 2. Knowing that the entry or exit of the person involves one or more acts of coercion against the person, one or more acts of deception of the person, or both, or b. The reception, recruitment, transport, transfer, concealment, or harboring of a person in New Zealand or any other state. I. For the purpose of exploiting or facilitating the exploitation of the person, or 2. Knowing that the reception, recruitment, transport, transfer, concealment, or harboring of the person involves one or more acts of coercion against the person, one or more acts of deception of the person, or both. 2. The penalty is imprisonment for a term not exceeding 20 years, a fine not exceeding $500,000, or both. 3. Proceedings may be brought under this section even if a. Parts of the process by which the person was exploited, coerced, or deceived were accomplished without an act of exploitation, coercion, or deception. b. The person exploited, coerced, or deceived I. Did not in fact enter or exit the state concerned, or 2. Was not in fact received, recruited, transported, transferred, concealed, or harbored in the state concerned. 4. For the purposes of this section, exploit, in relation to a person, means to cause, or to have caused, that person, by an act of deception or coercion, to be involved in a. Prostitution or other sexual services. b. Slavery, practices similar to slavery, servitude, forced labor, or other forced services. c. The removal of organs.